How does IHL apply to private military and security companies, PMSCs? Imagine a world where private companies are taking on roles traditionally held by national armies. That's what private military and security companies are doing today. They operate in conflict zones, providing security, training, and sometimes even engaging in combat. But how does international law, specifically International Humanitarian Law, or IHL, regulate their actions? That's what we're here to find out. First, IHL applies to all parties involved in armed conflicts, including non-state actors like PMSCs. While these companies are not considered official parties to the conflict, their employees can be subject to IHL if they participate directly in hostilities. This means if a PMSC employee fires a weapon or supports combat operations, they could be seen as combatants or unlawful combatants under IHL. This affects their rights and protections, such as prisoner status or protections from torture. The law also requires a clear distinction between civilians and combatants. PMSCs don't fit neatly into either category because they are private actors. If they engage directly in fighting, they might be treated as combatants. If they only provide security or logistical support, they are more like civilians. This ambiguity makes it tricky to determine their legal status and what protections they should receive. PMSCs are governed by both national laws and international rules. Countries that hire these companies must ensure they follow IHL. This includes investigating any violations and prosecuting those responsible for war crimes or abuses. Holding PMSCs accountable is a challenge because their actions can sometimes cause civilian harm, and oversight varies from country to country. Now, it's important to understand that IHL does not ban PMSCs outright. It does ban mercenaries, which are defined narrowly under international treaties. Most PMSC personnel do not meet this strict definition, so IHL treats them differently from mercenaries. This means PMSCs are not automatically considered illegal, but their conduct still must comply with the laws of war. When PMSCs operate in conflict zones, they must respect the core principles of IHL. They need to protect civilians, avoid unnecessary suffering, and minimize damage to civilian objects. They are expected to follow rules on proportionality and distinction, which means avoiding harm to civilians and only using force when necessary. Enforcing IHL on PMSCs is not always straightforward. Because they operate across borders and often under different national laws, it can be hard to hold them accountable. That's why many experts recommend clarifying their legal status, providing proper training on IHL, and strengthening oversight by states. Transparency and accountability are key to making sure these companies respect humanitarian standards. In summary, IHL applies to PMSCs mainly through the conduct of their personnel during armed conflicts. They must respect the laws that protect civilians and limit the methods of warfare. States that hire PMSCs are responsible for ensuring they follow these rules, and PMSCs themselves need to understand their legal obligations. As their role in conflicts grows, ongoing efforts are needed to clarify their legal status and improve oversight, so civilians remain protected and the laws of war are upheld.